Let me take you to a live event. Advocate Tembeka Ngcukaitobi is briefing media about that report into alleged racial profiling by medical aid schemes.
Mr. Vemchengov, SC, and the expert evidence of Professor Melissa Steyn. We came to the conclusion that there is an overwhelming racial discrimination in outcomes in fraud, waste, and abuse investigations conducted by Discovery, by GEMS, and by Medskin between 2012 and 2019. This amounts to unfair racial discrimination as defined in Section 9 of the Constitution, as well as in the Equality Act. Points of emphasis. This is an interim report, and these are interim findings. We have 6 weeks from today to enable each and every scheme that is affected to present further rebuttal of our report. We hope that the final report will be enriched by the submissions to be made in the next 6 weeks. In relation to the question of unfair process, in other words, the general unfair process, which is unrelated to race, what we have found is that the procedures that are followed by the schemes when they interact with practitioners generally, whether you are black, white, or colored or Indian, when they implement their powers under Section 59 of the Medical Schemes Act, there is procedural unfairness. And the procedural unfairness is most profound when it comes to the absence of a hearing for a medical practitioner to dispute whether or not they have committed fraud. Sometimes an allegation suffices as proof. But there is also unfairness when a scheme decides on what amount to be clawed back or to be recovered. For those who do not know, typically when a scheme investigates a doctor who has made a false claim or an allegedly false claim, it will not investigate each and every claim for the past 3 years or the past 5 years. They generally make an assessment of the likelihood that the claims that you have submitted would also have been affected by improper practices. And thereafter, based on that generic assessment, they will impose an amount to claw back, to take back from the practice. Some doctors came to us and they told us at the panel, which was a public process, that the impact of these recoveries on their practices can be quite severe. One doctor said, my practice is 90% dependent on medical schemes. If they clawed back, recovered, took amounts from me, that would amount to a 90% reduction in my income. I have to close my practice. This is why it is absolutely crucial, not that fraud, waste, and abuse should not be combated. It should be combated. We agree with that fully. But it is crucial that when it is combated, the procedures that are followed are fair procedures. So a doctor needs to be given a fair warning about the allegations. They need to be given a fair opportunity to contest the allegations. They need to be given a fair opportunity, if they admit some of the allegations, to contest the amount that a scheme says should be recovered. This is what applies across the board in this country. This is what happens because it is required by Section 33 of the Constitution, and because it is required by the principle of legality, which also implies rationality in the way in which schemes operate. We have assessed, there were disputes, and most of you may not be interested in the final legalities, but the basic distinction was medical schemes saying we operate in the private sphere and we are therefore not bound by the rules of public law. What we have come to the conclusion is that even though one may say that medical schemes operate in the private sphere, they are nevertheless bound by the rules of procedural fairness because of the nature of the power that they hold, that power coming from the Act and the impact of that power on the public. I'll tell you what we mean about the impact of that power on the public. A doctor from East London, Dr. Ngcukaitobi, came to the panel to give evidence. She came together with her patients. She told us that when she was put on so-called indirect payment or suspended from a medical scheme, the impact was not just on her in relation to her income, it was also on her patients, because it meant that she could not continue servicing those patients and they had to find an alternative doctor. If you are in a rural setting like the Eastern Cape or KwaZulu-Natal, finding an alternative doctor is not an easy thing. And so the impact of the conduct of the schemes goes beyond that bilateral relationship with a doctor, but it also affects patients and therefore affects accessibility of medical services to patients that ordinarily would not have access to those services. And hence we have emphasized in our findings that procedural fairness, which means telling a person what is the allegation against them, giving a chance to contest the allegation, telling them that you propose deducting an amount and conducting those conversations in an atmosphere that is non-adversarial and non-intimidatory. Some doctors complained of sheer intimidation by schemes, which makes them to simply submit to any demands by medical schemes. The final point to be made here is that medical schemes have stressed the significance of combating fraud, waste, and abuse as necessary to sustain their ability as schemes to continue providing the services that they provide. We have overwhelmingly endorsed this as a genuine concern and as something that this country, if anyone knows anything about South Africa, already faces a significant problem of enforcement of its laws. What we have been critical of is, although fraud, waste, and abuse ought to be tackled and it ought to be combated without hesitation and without equivocation, it is necessary that it must be done in a way that is not disproportionately impactful. In other words, innocent people should not be found guilty because the correct procedures have not been followed. So in sum, we emphasize that we had no power to find anyone guilty. We were not appointed to investigate the veracity of each and every individual claim of unfair treatment and unfair discrimination. But we would be failing in our duty if we ignored the degrading, humiliating, and distressing impact of racial discrimination against the individuals who testified before us. And part of our function was to provide a platform for the expression of individual experiences of racial discrimination and other forms of unfair treatment. We do not believe that we have covered each and every possible complaint by providers against schemes, nor was this our mandate. We also do not claim to have explored all possible manifestations of racial discrimination and unfair procedures. But we have received sufficient data and information to make informed and reliable conclusions of the patterns of conduct by the schemes. In certain respects, our conclusions, which are evidence-based, accord with individual experiences. Affirming these individual experiences as fact and as finding has been an essential element of the work of the panel, confirming that the majority of the complaints were not frivolously made. Our expectation is for a constructive engagement with the findings and recommendations of this report to ensue. We do not wish for hostility. We do not wish for acrimony. Rather than conclusive, our findings will hopefully provide a basis for the necessary reconstructive work. We must always remember that South Africa is still engaging with the consequences of apartheid, and we have only had 25 years to do so. we are still engaging with the consequences of colonialism. We have only had 25 years to do so. So what we hope is that our findings will provide the necessary basis for the reconstructive work which must be undertaken by the role players in the medical schemes industry. We are not in the industry. We are only 3 advocates. And so we were able to assess the conduct within the industry from an objective and non-interested perspective. We do not see this as a binary conflict between schemes and providers, but we see it as reflective of the fissures of the past that remain unresolved. Thank you, SJ. We shall take questions. My colleagues will answer the questions as and when they come.